number 8 on this afternoon's calendar, Konkur versus Utica Academy of Science Charter School. Counsel?
Good afternoon, Your Honors. My name is David Goldbess. I represent the appellant. I respectfully request 2 minutes of my time for rebuttal.
Yes, sir.
May it please the Court, the appellant brings error from the Fourth Department's decision dismissing on the law his claim for damages under Section 198 of the labor law. That law is called the anti-kickback statute, and the pleadings are taken as true, and they detail the coercion, the force, the intimidation which he suffered as an employee of the Utica Charter School, which worked in conjunction with the defendant, a nonprofit organization, which worked to separate him from his wages in the form of kickbacks. And he has sued for those kickbacks under the labor law, which is located in Article 6 of the labor law. The statute itself is oddly constructed from a grammatical point of view because it begins by saying the practice of forcing the kickbacks is unlawful. And further, after it defines what the kickbacks are and what the unlawful practice is, it goes on to say that this practice shall constitute a misdemeanor. The appellate division read that section, that statute, I believe, with blinders in a short-sighted way because it overlooked the
Counsel, I'm on the screen.
On the screen, sir.
On the screen, Counsel. Hello. Happy New Year. I wanted to ask you, how, if at all, does the fact that the courts of this state had recognized a private cause of action for these kind of kickback denials of wage, the courts had recognized that private civil cause of action for these kickback claims, prior to the movement of the language that was found in the penal law to the labor law, how does that affect your argument? Does that support that then the legislature must have understood that a private right of action also existed? Or does it undermine the argument that somehow the private right of action is localized in labor law?
I would say that it supports it because we have a traditional cause of action for extortion. The penal law had outlawed extortion, and the 1936 case cited in my brief did recognize the cause and sustain the cause of action before the enactment of Labor Law 198. And I would say that it is an enhancement of the right which was granted by common law to be distinguished from the cases in which this court and the courts of New York have said that the implication of a private right of action should not lie if the private cause of action would contradict legislation. And in the case that's cited by the Fourth Department, Stoganovich versus Donolfo, the court said that there exists, we're not going too far afield with piercing the corporate veil, as the wage earner and Stoganovich wanted. The piercing the corporate veil is an extraordinary remedy. It was granted by statute. And to the extent that extortion is already prohibited by common law, and the legislature wanted to enhance the common law right, I would say that the legislature is mindful, has been mindful of the common law and wanted to apply it with the extra protections to the wage earner that Article 6 has.
Counsel, the commissioner can also bring some type of proceeding here, right? There's some type of administrative proceeding available, is that right?
That is correct, and I would say that the existence of the administrative remedy warrants the private right of remedy because...
I understand that point, but so under that type of proceeding, the the Labor Department can recover money that then goes to the harmed employee, right? That they can recover money that then will be given to the employee at some point.
That's correct. That's
Right.
correct.
And as I also understand some of the federal cases, there was a point where the statute was amended to specifically provide private rights of actions in certain sections, but not this one. And that was relied upon in some of the federal courts finding no private right of action here.
That is true. The Southern District and the Western District have agreed with the Fourth Department. But again, I say that this court should overlook the authority of those cases because they're not well-reasoned and they do not take into account the text of the statute, the context.
But why isn't that a good reason, that the statute was amended to provide it in some cases, but not here?
The statute does provide it because by one reading, it says that the practice is unlawful. And a reasonable corollary...
But a private, maybe, and correct me if I'm wrong, but I thought that the statute was amended to provide private rights of action under certain subsections, but not the one that you want to use.
The statute was developed, the Article 6 was developed to protect wage earners, and the amendments that you refer to are unknown to me. I have never seen legislation, any act or any bill jacket of the legislature that says the private right of action under 198B is prohibited. Therefore, we must look to...
Well, we wouldn't be here if we had that, right?
Well, certainly, and we often talk about the intent of the legislature, but it is difficult to read the minds of these men and women, and so I think the more beneficial approach is to determine the legislative purpose, that is, the legislative scheme. And we have a legislative scheme here of Article 6 designed to protect the wage earner, designed to give him or her prompt remedies, designed to deter the deprivation of wages in various forms. And I would add that 1982 of the labor law allows all the remedies. It is cumulative to say...
Counsel, I'm back on the screen, Counsel. I just want to clarify something from your interpretation of the labor law. If the Commissioner of Labor, if they do proceed in an action to recover wages under other provisions, let's not even talk about this provision for one moment, does that mean that the private individual could not forego that process and seek on their own for those wages? I'm not talking about double dipping. In other words, can they run parallel? Or is it that the wage owner can on their own say, you know, I thank you, Commissioner, I want to proceed on my own, thank you very much? Or does the Commissioner get to decide that only they can pursue the lost wages on behalf of the worker?
The Commissioner takes the claim on an assignment, and once he or she has the assignment, the case is in the Department of Labor for its prosecution. And
So the Commissioner, so to clarify then from your perspective, the Commissioner cannot proceed if the wage earner decides not to assign that right, that private right of action. Is that what you're saying?
That's correct. It is a two-tier...
The Commissioner may have other law enforcement tools available to the Commissioner to go against a particular employer, but when it comes to the individual's wages, it is the wage earner's ultimate decision that controls whether or not to proceed. Is that
That is
correct?
correct. That is correct, Your Honor. It's been my experience from my practice that the wage earner either goes to the Department of Labor or she goes to the private counsel. And for wage claims, there are two tiers or two tracks of enforcement, one by the Commissioner and one by the private cause of action. And I would remind the court that Section 198, subsection 2 reads, "The remedies provided in this article may be enforced simultaneously or consecutively so far as not inconsistent with each other. But again, it's the practice that if the state has the claim, it proceeds. If it learns that private counsel is involved, they defer to private counsel.
And thank you, counsel. Counsel?
Thank you. Matthew Piston on behalf of Respondent Highway Education, doing business as the Turkish Cultural Center. Section 198-B of the labor law does not expressly provide a private cause of action to recover kickbacks. It is solely...
Counsel, can I just clarify? I'm on the screen. Happy New Year.
Happy New Year.
Thank you. I just want to clarify, putting aside the argument on the labor law, do you agree that given the existence of the private right of action before the movement of the language from the penal law into the labor law, that that private right of action was not extinguished with that move? Not under the labor law, just as recognized by these courts.
I think I understand your question to be, do I believe that the common law right that existed prior to this codification in the penal law,
Yes.
whether or not that codification extinguished the common law claim?
Yes, in your view, let's put aside the labor law for one moment, is it your view that that would survive regardless of the way this court interprets the labor law?
It is my view that it would not survive, that the legislature, I think it can be presumed, understood what the common law was at the time and chose to disinclude that right within the statute.
Well, then how would that be in furtherance of the labor laws, given that the labor law does recognize private rights of action of wage earners to recover their wages? I mean, isn't this just another version of wage theft?
Well, again, when this was codified, it was codified under the penal statutes.
But I'm talking about the language now in the labor law. Isn't this just another form of wage theft? And if you're correct, would we not anticipate that the legislature would be extremely clear, given that otherwise a wage earner has a private right of action to sue to get their wages, properly withheld or threatened, and required to donate the wages?
Sure. Under Article 6 of the labor law, they explicitly and expressly do provide certain causes of action for private individuals. And they did not provide it in 198-B. So again, under the...
I guess, again, let's go one step further. Is that really necessary when there is already a private right of action? So you're just moving it over, and there you have the private right of action. That's why I asked you if you thought the common law one was extinguished, or if you thought there was something else going on here. And it strikes me that you're basically saying not only did the legislature understand that there was this private action, and when they moved it over, it's not just a question of did they also, in addition to wanting to continue the criminal penalty for kickbacks, they also expressly wanted to eliminate the private right of action, even though everything else in the labor law and given the overarching purpose of the labor law would be to allow a wage owner to seek claim to their wages. That's why I asked the question, because it seems to me difficult to understand that position.
Well,
It would be one thing if you argued, no, the common law one continues, but, the labor law and whatever other benefits you might get under the labor law, a private right of action doesn't apply here. But it strikes me as a much more challenging, in my view, challenging position that you've taken.
Is there a common law claim here?
there is no common law claim. This is strictly under 198-B.
So why doesn't section 198, because it's also under 198, right? Is 198 pleaded?
I'm still a little unclear about what that pleading was. They did bring
Did they
claims
mention
under
198?
198, but
Okay.
in
So-
my view, that was strictly their measure of damages.
198 was their measure of damages? Doesn't the fair reading of 198 contemplate a private right of action?
In certain circumstances, yes, but
Well, what are the circumstances? That's for any wage claim, no?
again, this is not a wage claim. This is a kickback. So this is not a wage claim. My client, Highway Education, was not an employer.
So how do we know what's a wage claim and what's a kickback?
Well, in this case, they brought it under 198-B.
And 198, no?
That has not survived. Again, the only, as I read the pleadings and as the Fourth Department found, 198, the mention of 198 only deals with the measure of damages and the level of damages if they were successful in proving 198-B. And in it, they were attempting to seek attorney's fees. They were trying to seek a recoupment of the funds that were kicked back, and I believe it was double damages as well.
So you don't read 198 as providing a civil action for violations of Section 6, broadly?
Well, there's been other indications, 198-A and 198-C, which are criminal, and this court has ruled and affirmed the decision of the Fourth Department saying that they are criminal in nature and there's no private cause of action. So I think just because something appears in Article 6 doesn't necessarily mean that there's automatically a private cause of action.
Yes, but you see, this is where I have the difficulty, because there was a civil act, or has been a civil action before that movement. So it's not like the legislature created a brand new cause of action or created, wanted to recognize that conduct was criminally unlawful and stopped there. You already have the civil right of action. So that's why I'm having difficulty. But let me ask you one other thing, because I just want to be crystal clear about your position. If I understand your position, the logical conclusion would be that if for whatever reason, the district attorney, the local district attorney, and the commissioner of labor decide not to pursue an individual's complaint, right? They might bring it to either or both, a complaint of an alleged kickback, that wage earner has no recourse. I just want to be clear. Is that your position?
I think it depends on who it is that they are attempting to retrieve that quote-unquote kickback from. Is it a third party or is it an employer? And if it's an employer and there is a requirement by an employer to kick back wages, then I think under 193 and 198, they have a private cause of action to recoup those. If it's a third
So now let me just clarify. So your position is, if indeed your kickback action is against an employer, you may proceed civilly, privately. Your argument here is that you're just not the employer. Is that correct?
No, Your Honor. I don't think that they have a cause of action under 198-B. But if we're talking about employer-employee wages and an illegal deduction of wages, or however you want to categorize it, then I think that there are other statutes within Article 6 that would apply and would give.
Oh, I see. Because you're arguing that labeling something a kickback is just one way of expressing what is otherwise a type of wage theft. Is that correct?
The way that I read 198-B, it's a requirement to pay over wages in order to keep their job. Mm-hmm. And that is it is criminal to require that or to do that on behalf.
Yes, because it's a diminishment of their wages, right? It's like saying, I mean, it's hard to see the difference between, here's $100, if you want to come tomorrow, you're going to give me $20 back, versus here's $80, I've taken out 20 so that you can have your job tomorrow.
I did not read 198-B to actually have a payment over of wages. I think that threat of losing your job or not having that job is sufficient to violate 198-B and to be criminally prosecuted.
Thank you.
Thank you, counsel. Counsel, your rebuttal?
May it please the court, we did plead 198. We sought our remedy under 198 based on the violation of 198B. We were deprived of wages by kickbacks. And if the Second Department's ruling is affirmed, it would lead to an anomalous result, which is that the wage earner could be deprived of wages by his employer for unintentional reasons. He couldn't pay, he forgot to pay, he didn't want to pay, and that employer would have to answer in 198 for double damages and attorney's fees and all the remedies in 198. But if that same employer used force or threat of force to force the kickback, and violate 198B, there would be no civil right of action in that situation. And likewise, there would be no civil action if the employer, through that same force, used a third party to cause that same intimidation and that same, what the legislature called, vicious practice. That is an anomaly, and that is a fair implication we submit of the statute to allow civil action for kickbacks. Thank you.
Thank you, counsel.